So we're going to jump back into Jarnail Singh's testimony to the Post Office Horizon IT inquiry and specifically focus on the request to Fujitsu with regards to existing bugs in Horizon, and Gareth Jenkins is showing that he's unsure on answering it based on the lock-in issue, which is then not reported seemingly by Jarnail Singh to Counsel Warwick Tatford. When he's asked about this, he asks for some time to stop the inquiry to confer with his solicitor and confirms it's relating to self-incrimination. So what's happening? Let's jump into the inquiry.
Picking up where we left off before lunch, we were looking at the email that Mr. Jones, the head of legal at Fujitsu, had sent you on the 5th of February 2010. Perhaps if we just remind ourselves of that. FUJ 0015 2930. And you remember we were looking at this before lunch, and it's this critical issue of what started as paragraph 7 of Mr. Tatford's advice about getting out of Fujitsu known or recognised errors or issues with the Horizon system, the watering down, as I called it, of that request, the putting of that to Fujitsu and Mr. Jenkins, and the reply coming back, he's not currently in a position to make a clear statement.
Yes.
Can we just look at the draft witness statement that was attached to the email by looking at FUJ 0012 2723? And if we look at page 2, please, can you see that Mr. Jenkins internally says, i.e. to Mr. Jones and Ms. Thomas, brief responses as follows, but I'm not sure that I should put them in a witness statement. And then number 3, this is where I'm reluctant to make a clear statement. I'm aware of one problem where transactions have been lost in particular circumstances due to locking issues, etc., which was cut into the email that you yourself received.
And people have pointed out before, in an event system like this where there's message queuing involved, then you shouldn't ever lose transactions due to locking issues. So that's kind of a tacit, implicit acceptance that actually we've either not got a queuing system at all or it's not working because actually transactions are being lost due to locking issues, which could then cause discrepancies, which then would blow a hole in the case even before you actually review the logs themselves, which they still haven't obtained, which, by the way, even if they admit there is this locking issue, if they could then get the transaction logs and prove that this didn't happen at this office, then they would still have a case. But obviously it does start to undermine the Horizon is robust narrative that is coming out from the post office at this time.
And then if we scroll up, please, and a little further, you can see that that is indeed forwarded on to you. Can you see that?
Yes.
What did you think when you read that Mr. Jenkins said he was reluctant to make a clear statement over whether there were known issues or problems with the Horizon system?
Sorry, say that again, sorry.
What did you think when you received a communication which said that Mr. Jenkins was reluctant to make a clear statement over whether there were any known problems with Horizon?
I mean, that should set some alarm bells off, surely, because you're thinking, oh, is it not as robust as we think it is?
I don't know. I can't think now as to what I was thinking at that time, or what we did about to deal with it.
What about what is said there? It's possible for there to be problems where transactions have been lost in particular circumstances due to locking issues. What further information did you seek from Mr. Jones or Fujitsu more generally as to what this problem was and what the background to it was?
I honestly don't know. I mean, I don't know what it was because I haven't got the whole file.
See, and the problem is with this, I mean, admittedly, it's a long time ago, so that can account for some of the memory issues, but it only leaves people to fill in the blanks and think, was it convenient then not to ask about any potential issues even after they're flagged to you? Because he's saying, I can't come on without the transaction logs, so if we don't ask for the transaction logs, we've not got an issue. You would hope not, but it leaves open that possibility without a definitive conclusion the other way.
And certainly, I was working with other people. I would have sought advice as to what directions we take from there. Certainly, the barrister is working alongside me together with the head of criminal law team. I mean, I as I say, this is the first case of this nature. That's why I wouldn't have taken that case on by myself. I would have had other people working alongside with me, and it was that period, I think, in that year where I think I took time off, certainly, and we had my head of criminal law team working alongside me, who was caretaking while I was away.
Did you take any steps to understand what the issue was with Horizon, which could cause transactions to be lost?
I don't recall. From what this is the only thing, or whatever you've given in your, the papers you've submitted to me. Apart from that, I can't really add any more.
Given that your counsel, Warwick Tatford, had originally advised the Post Office in relation to its disclosure obligations to ask Fujitsu whether it was aware of any other Horizon errors that had been found at any sub-post office, and this information was conveyed in response. Did you take any steps to ensure that the Post Office met its disclosure obligations in relation to at least this information?
I don't recall. I mean, I can't. I don't know. I haven't got the full information in front of me as to what steps we took.
Because if that had have been overlooked, then again, that would have been an oversight again, surely, because that was a duty that was placed on Jarnail Singh here, and the Post Office more widely as an organisation by Counsel Warwick Tatford in his advice note to Jarnail Singh.
We've seen on the disclosure schedule that there is no mention of any document exchanged with Fujitsu, nor any email exchanged with Fujitsu. There's no disclosure on the unused schedule of any communications with that third-party provider, is there?
Not on that schedule. Should have been.
So this is the 5th of February. Can we look, please, at poll 305-4162, your email of the 22nd of February to Warwick Tatford and John Longman. And you say, here with my replies to the defence's third schedule. Be grateful to John if you could read through all the replies, but in particular, detailed responses to a list of them. Responses by the end of business today, so you could forward on to the defence's solicitors. And then at 2, you proposed to say to Izzy Hogg, we're well aware of our statutory duty of disclosure. As you know, the prosecution have reviewed a large volume of material. The only material disclosable is Calendar Place, I think you meant Calendar Square. As we know, Mr. Jenkins is making full investigations so the position can be ascertained. The information that you received from Mr. Jenkins via Mr. Jones and Fujitsu was not disclosed by you in this proposed communication to the defence solicitors, was it?
I don't recall.
Well, it's not.
I mean, additionally to that, it doesn't even look like it's disclosed internally within the Post Office, which is a bit bizarre, because surely you need to keep your own counsel informed of every single piece of information you receive, and then that gives them the opportunity to spot errors, which I'm pretty sure is what Jarnail Singh alluded to the process being earlier.
Not there, is it?
Can I just stop for 5 minutes and have a chat with my solicitor on this, if it's possible, sir?
Well, that's a rather unorthodox request in the sense that witnesses don't normally have a chat with their solicitor.
Well, advice then, because...
If it relates to the warning I gave you at the beginning of your evidence about self-incrimination, then I will permit it. Does it relate to that?
Well, so to a degree, because this information is very old. And you 12, 13 years on, I have not seen the file. I've been away from this type of case Even my honest belief as to the previous question asked of me by your inquiry counsel as to whether whether Mr. Jenkins was expert or not expert. Again, there's a lot of information isn't solely down to me, because it's sort of done by the whole team because of the nature of the case, and because of this being the first of post office cases where the matter's gone to trial.
All right, hang on, Mr. Singh. In the circumstances that are developing, Mr. Beer, can you think of any cogent reason why I should refuse Mr. Singh's request?
So I think there needs to be a limitation placed upon it, because
I think the limitation in reality will be that I will limit it to 5 minutes, Mr. Beer.
Yes, because the I wasn't thinking more in terms of time. I was thinking in terms of content.
No, well, I know. I was simply observing that if I limit it in time, the content is likely to be limited as well. But maybe that's too pragmatic. Anyway, all right. Is anyone else representing a co-participant? Does he or she wish to provide a cogent reason why I shouldn't accede to this request?
No, I'm getting shakes of heads from Post Office, Howe & Co, Hodgels, Fujitsu and Gareth Jenkins representatives.
Right.
It's just HJA, I think, you're thinking about.
Mr. Singh, I'm going to afford you 5 minutes, literally. I'm going to specify, since it arose in relation to this document, that the discussion must relate only to the document which is now on the screen, and in particular the highlighted part at paragraph 2, and anything which bears upon that in relation to self-incrimination. All right? So with those words, what's the time now, Mr. Beer?
Just gone 25 past. Should we say 25 to, sir?
Yeah, 25 to 3, we will return. All right? So you need to get your skates on, Mr. Singh, all right?
No problem.
Thank you.
So
Well, that was certainly interesting. I guess we will see what that was all about potentially with his next answer.
can you see and hear us?
Yes, I can. Thank you.
Mr. Singh, is there anything that you wanted to convey to the chairman, having had that?
No, thank you, sir. Thank you for the time. It's just to clarify my head. I think I needed time. That's fine. That's okay. Can you ask the question again? Then I can.
Thank you. This draft communication to the defence solicitor, Izzy Hogg, was to tell her that you, the prosecution, were, quote, well aware of our statutory duty of disclosure. As you know, the prosecution has reviewed a large volume of material. The only material disclosable is Calendar Place. And my question was, why did you not reveal the information that Mr. Jenkins had provided you through Fujitsu about a known problem which caused transactions to disappear or to be lost?
This is to Mr. Warwick Tedford and Longman, isn't it?
Yes, it's a draft email.
Draft email. I'm working alongside the council, but I don't.
They can't possibly advise, though, on this lock-in issue if they're not made aware of it, can they? Unless they're aware through other means. So surely that is the issue that's being pointed out here, the lock-in issue that Gareth Jenkins has brought up in his own email. We've seen internally at Fujitsu first, but then which David Jones, the head of legal at Fujitsu, has passed on to Jarnail Singh.
I don't recall or remember this. I can't answer. I don't know I don't recall.
But do you agree that the information that you had received should have been revealed to the defence? I think you've agreed that already, in fact, before the break. But do you agree that it should have been revealed in this response to the defence? Again,
it's such a long time ago. I'm trying to... a lot of it is basically since I've left doing this sort of work, it's unmanageable, the amount of material I had. Certainly I do not remember, I do not recall. I can't really assist the inquiry any more than that, because it's not something that I would have retained to give you an answer for. So I don't remember, I don't I don't recall.